The title of my presentation, I was really thinking about what to say to you because there are so many experts in the field of non-discrimination today in the room. I decided to try to paint a picture that is very general and to try to see where we are in this global picture. So I decided to title my presentation, Global Challenges in Anti-Discrimination Between Traditional Biases, Political Turmoil, and Technological Advancement. So, ladies and gentlemen, it's really wonderful to be here at the Faculty of Law of the University of Ljubljana, also my alma mater when it comes to a law degree and my PhD. And I'm really happy that it's this faculty, together with the equality body of Slovenia, that is hosting the Berkeley Conference this year. It's one of the key conferences on non-discrimination and equality in the world, and it's really not a small thing for this conference to be held in Ljubljana. So I would like to congratulate the organizers for their decision to host this excellent event here, and we can only imagine how much work has gone into making sure that all of us feel welcome and heard at this conference. And of course, I would like to thank the organizers, particularly Miha Lobnik, head of the Slovenian Equality Body, who invited me to deliver this keynote address. I feel very honored and also very humble, but also I feel excited and I feel motivated to continue working in the field of non-discrimination, even in my current function. In my speech, I would like to address the main global challenges concerning discrimination, non-discrimination law, and equality policies globally. Of course, it's not a small task, but I will just try to paint this, as I said, a relatively global picture. So the challenges in all of our countries that we are facing are multifaceted and deeply rooted in the historical, social, legal, and economic systems. Of course, these challenges vary a lot by region, but they also share common themes that hinder progress towards equality. Deep-seated social attitudes normalize the phenomena of racism, sexism, homophobia, casteism in some countries, xenophobia, and ableism. Cultural traditions or religious beliefs are sometimes invoked to justify discrimination. Marginalized groups still lack access to decision-making positions, perpetuating cycles of exclusion. Then there is also the embedded bias that remains one of the main causes of discriminatory practices, as it is often built into the fabric of the institutions, for example, in the legal systems, in education, in policing, and in healthcare. People who belong to more than one marginalized groups, for example, women of color, LGBTQ+ people, refugees, disabled ethnic minorities, and so on, face compound and intersectional discrimination. The problem is that many policies address discrimination in a siloed way, failing to consider these intersectional experiences. So they mostly address one person or circumstance at a time. Many countries, of course, now already have anti-discrimination law on paper, but they are poorly enforced sometimes and undermined by judicial bias. Corruption or lack of judicial independence often hinder victims' ability to seek justice. There are also problems with detecting and measuring systemic discrimination. In many regions, there is a limited or no disaggregated data to measure discrimination. Collecting identity-based data can be politically sensitive or pose risks to vulnerable populations and privacy principles. Slovenia is certainly one of those countries that has been refusing for decades to collect disaggregated data in some fields, invoking data protection guarantees. We are also observing immense shifts in national and international politics that negatively influence equality. Growing populist and authoritarian movements often scapegoat minorities for the problems that burden the society. Politicians sometimes stoke division for electoral gains, but this is also seriously undermining social cohesion in their own societies. This year, we have seen some extreme cases in politics, such as the prohibition of diversity and inclusion policies in the United States, the so-called DAY policies. One of the first executive orders issued by the United States President Donald Trump was titled, "Ending Radical and Wasteful Government Day Programs and Preferencing." It ordered all federal agencies to not only discontinue any program, that has been related to diversity, equality, and inclusion, but also to provide lists of positions, committees, programs, services, activities, budgets, and expenditures, as well as grants and grantees that received federal funding for activities in this field. The effects of the order went as far as federal employees being fired because they attended a diversity and equality training in the past, even though this training was mandatory for them at the time, and even though that firing someone on this basis is illegal. The US government even issued a list of words that are used for flagging programs that should be canceled and content that should be deleted from the federal government websites. I will now elaborate these words for you so that we can all immerse into these new realities that we are seeing. So these words are the following. I'm talking about the prohibited words that are used for flagging the content that needs to be deleted from the websites. So these words are abortion, accessibility, advocacy, affirmative action, affordable housing, anti-racism, asexual, assigned female, male at birth, at risk, autism, belong, bias, biologically female or male, bisexual, Black and Latin, community diversity, community equity, cultural differences, culturally appropriate, disability, disadvantage, discrimination, disparity, diversity, equity, and inclusion, elderly, equal opportunity, equality, equity, ethnicity, evidence-based, exclusion, feminism, gender, gender-based violence, gender diversity, gender dysphoria, gender expression, gender identity, gender ideology, gender nonconformity, gender transition, gender-affirming care, gendered, genders, hate speech, health disparity, identity, immigrants, inclusion, indigenous, inequality, injustice, integration, intersectionality, intersex, lesbian, LGBTQ, male-dominated, marginalized, men who have sex with men, mental health, minority, multicultural, non-binary, oppression, people of color, privilege, promoting diversity, pronoun, queer, race, racial justice, racism, segregation, sexuality, social justice, stereotype, trans, transsexual, transgender, underrepresentation, victim, vulnerable, white privilege, woman, and women in leadership. But that's actually all we care about, right? Especially people in this room. So should we want to abide by this list, there would be nothing left to discuss at this conference. And this keynote speech would certainly not exist. I'm also a member of ECRI, as Micha said before, European Commission Against Racism and Intolerance, that works within the Council of Europe. We undertook a little experiment. We covered the prohibited words in the ECRI's annual report on the activities that we did in the past year. The report became blank. There was nothing to report about left. And I should say that I only chose the words that are relevant for the theme that we are discussing here today. And I should say that it's additionally worrying that the list of prohibited words also includes everything related to the protection of the environment, climate change, energy, and safe drinking water, which is a whole other shocking problem if you think about it. So further challenges that I want to discuss are caused by the technological advancement that can benefit us all in, of course, many areas. We profit from this advancement every day in our everyday life. However, algorithms also perpetuate or amplify biases, as we know, if it's not carefully designed and audited. The traps and dangers of artificial intelligence are already widely discussed, so I will not go further into this issue, but I agree that a great attention must be paid to this topic. Artificial intelligence also plays a crucial role in how the digital platforms are used. If you have been using these platforms for a few years now, you have probably noticed how much they have changed. First of all, one can hardly see content from the people that we follow, while most of the content are actually commercials and just the content that is paid for or produced by the AI. Digital platforms are often used to spread hate and misinformation with limited accountability. A lot of these discriminatory posts are also generated by the AI, including pictures and videos. The question is now how much freedom of expression and freedom of speech protection should be awarded to such content, if it should be awarded at all, because it's not produced by human beings. We should also keep in mind how much such hateful content endangers the principles of non-discrimination, equality and inclusion, but also democracy and freedom as such. I wish to address briefly the topic of migration in the context of non-discrimination, as it is an issue that receives a lot of attention in the public discourse. The law tends to separate migration issues from non-discrimination. Why is it so? The legislatures drafted the law in such a way to ensure that the protection from discrimination does not cover differential treatment based on legal status of an individual or the lack of such status. Differential treatment on the grounds of legal status is actually engraved into the legal system. The legal system actually foresees it, including the European Convention on Human Rights. It has been resolved long ago in the law that the scope of rights a person is entitled to depends on the type of their legal status and not solely on the fact that they are a human being. However, it seems that this exclusion is often used as a pretext not to recognize even those rights that absolutely should not be dependent on whether or not an individual has a legal status or not. For example, the due process rights, the right to seek judicial review before deportation, or the right to claim protection from torture or inhuman or degrading treatment in another country. Even more, it seems that this exclusion of a legal status differentiation from discrimination protection is used as a carte blanche. It is sometimes understood by states as a freedom to act as they wish, without any kind of boundaries whatsoever. The most disturbing examples of the lowering of standards can again be observed in the United States. Many states are now either considering or already implementing schemes of deporting migrants not only to their own countries of origin, but also to third countries that are not even on the same continent as their own country, such as, for example, South Sudan. I believe that this is one of the cruelest moves that a country can actually undertake against an individual, as it interferes deeply with human dignity and interrupts any prospect whatsoever that this person might have for the future. It's one thing to be deported to the country of your origin, or at least a neighboring country, if your country of origin does not cooperate. It is something completely different to be deported to a foreign continent. I find these practices deeply morally wrong, even though they might not constitute discrimination under the European and national law. In this sense, I find problematic that in the recent decision of the US Supreme Court confirmed the deportation to a country that is not your own as constitutional. I find that deeply problematic and a clear sign that the US Supreme Court, unfortunately, is no longer, and actually hasn't been for quite some time, a court to look up to when human rights issues are at stake. I would now like to focus a little bit more on the recent decisions of the US Supreme Court that are related to the non-discrimination and have been subject to severe criticism by the US scholars. The first one is related to the so-called opt-out from school content for religious reasons. The US Supreme Court ruled a few days ago in Mahmoud versus Taylor that Montgomery County public schools must allow religious opt-outs from any lesson that parents believe will interfere with the religious development of their children, including LGBTQ-themed materials. The decision could have far-reaching consequences for public schools' ability to create an inclusive and welcoming environment that reflects diversity in their communities, as well as the school's ability to implement any secular lesson plan that may trigger religious objections. The wide wording of the decision will have a wide-ranging consequences. The decision was related to the concrete issue of LGBTQ content in schools. However, the wording of the decision extends to all content that might be interfering with the parents' religious rights, including content of science or, for example, of evolution. In the second case, that is only a few days old, the US Supreme Court ruled that states may deny people covered by Medicaid the freedom to choose Planned Parenthood as their healthcare provider. US law professors who teach courses about health and poverty law, as well as reproductive justice, think this ruling could restrict access to healthcare, including reproductive healthcare, for more than 78 million Americans who get health insurance coverage through the Medicaid program. Namely, Planned Parenthood insurance scheme is among the nation's top providers of reproductive services. It operates clinics where patients can get physical exams, cancer screenings, contraception, and other services. In 2018, the South Carolina governor issued an executive order that barred Medicaid reimbursement for healthcare providers in the state that offered abortion care. That was the reason why this reimbursement was prohibited. That meant Planned Parenthood would no longer be reimbursed for any type of care for Medicaid patients. So, while the case seems neutral, it actually has wide implications in the field of reproductive healthcare, which will affect women mostly. This is a very gendered issue. In the third case that I want to mention is known as the birthright citizenship case. In this case, the US Supreme Court limited the judge's use of nationwide injunctions. The case was not decided on the merits yet, but this first procedural decision is very restrictive. It means that protection from being stripped of citizenship will have to be sought by each individual person who will be affected by the measure. This is a question of access to justice, non-discrimination on the basis of national origin, as well as conformity with the Constitution. In addition to these individual cases that I mentioned, there are wider questions at stake concerning the US Supreme Court. As one of the leading constitutional law professors in the US, Steve Vladek from Georgetown University wrote, "We are witnessing a new kind of judicial supremacy in the United States, one that is very unpredictable and also very dangerous. In the fields of equal rights, due process, separation of church and state, and protection of minorities, this is quite visible." I realize that the US Supreme Court is, for most of the world, just the highest court of a foreign country. And perhaps you are thinking to yourself that the Americans are getting what they actually voted for, and that the rest of the world can ignore these judgments. But we have to take into account that this court is, or perhaps was, considered to be the most influential court in the world, as many other nations' highest courts have been relying on the US Supreme Court precedents in their own decision-making. In addition, as experience teaches us, many of the social and cultural norms and developments that start in the United States spread across the world due to their global cultural influence. Many legal scholars, including current and future judges in many of our countries, studied in the United States and are keen on invoking their court practices. So in my opinion, the developments at the US Supreme Court should not be underestimated, and since they are so negative, there is a need for precaution in other countries. For me personally, since I work as a judge, it is very important to be aware that the courts that we have once looked up might be changing, and hence we need to be prudent on which precedents we will take as the example and which not. Another question that I'm struggling with is how to deal with discrimination and equality in the time of the proximity of wars, this time by Russia against Ukraine and by Israel against Palestine, and the suffering and the allegations of war crimes, crimes against humanity, and genocide, as well as other crises related to these wars, for example, the refugee crisis or the energy crisis. In the context of these huge challenges that seem to be insurmountable, how do we continue to speak about non-discrimination and equality that don't seem to be so important comparing to war? What can be the way forward? I believe that in this context, overcoming discrimination-related challenges is possible, at least to some extent, and at least locally. National and even local challenges are more easily resolved than global and international ones. Transnational issue-based cooperation concerning a certain issue is still useful and empowering and can provide the way forward. Learning from practices that bring change still makes sense. In politics, elected representatives do have a choice if they are going to design solutions that benefit all people, including the marginalized groups, or are they going to join discriminatory populist discourses and violate the equality clauses of their own constitutions. On the legislative level, national and regional parliaments can still introduce measures to improve equality and inclusion, regardless of a difficult international situation. And they are doing that. There are numerous examples in different European countries where the parliaments have improved the legal protection for different groups in the recent years. These examples include legislation for stronger anti-discrimination protection, for example, in Germany, Norway, and Sweden, better protection of people with disabilities, for example, in the UK, strengthening of the protection of victims of gender-based violence, for example, in France and Germany, to further implement the Istanbul Convention. Then there are initiatives to achieve gender parity in corporate governance, which has been done by several countries due to the EU directive requirements. There are initiatives to strengthen collective actions in cases against discrimination, for example, in France. Spain, for instance, passed a law in 2023 that strengthens the rights of transgender individuals and tackles discrimination based on gender identity. Some countries are discussing to prohibit conversion practices, which is important for the LGBT community. Of course, not all the legislative developments in Europe are positive and in favor of equality. A lot needs to be done to improve non-discrimination protection in laws and practice. There is also still a lot to be done concerning the strengthening of the equality bodies. For example, Italy still doesn't have a proper independent equality body for all personal grounds. I specifically need to highlight the Hungarian examples of abolishing the equality body as an independent institution in 2021. Its functions were merged into the Office of the Commissioner for Fundamental Rights. This decision was met with criticism from human rights organizations who expressed concerns about the independence and effectiveness of the newly constituted body. Further, in March 2025, the Hungarian parliament also voted in favor of a bill which bans holding or attending assemblies that violate the law on the protection of children, which forbids promoting or displaying homosexuality and gender change to persons under the age of 18, which basically means banning the Budapest Pride. These are really not the measures one would expect in an EU member state. Another negative example comes from Poland, which further restricts access to abortion. This measure is heavily affecting women who are in most extreme cases even dying due to the lack of health care that they would need. In judiciary, the legal standards set by international courts are there for the judges to follow, including us. In the field of non-discrimination, they are relatively high, these standards, which is a result of the judicial dialogue, as well as the rising European consensus of what the standards concerning each individual right should be. We know that the European Court of Human Rights is looking for this consensus in certain fields, so it's up to the states to act first. The role for the national highest courts, Supreme and Constitutional Courts, is not only to implement the international legal standards, but also to remind the lower courts to do so. Since their existence, both European courts in Strasbourg and Luxembourg have developed a range of legal standards interpreting the anti-discrimination legislation. I would like to mention the most important decisions of the two courts from 2024 and 2025. This year, the Strasbourg Court reiterated the principles established already in older case DH versus the Czech Republic that concerns segregation of Roma children in education. Namely, in May 2025, it issued a judgment in the case Salai versus Slovakia. The case concerned the discriminatory placement of a Roma pupil in special education classes for children with mild intellectual disabilities in Slovakia. The ECHR found that Slovakia violated the right to education and the prohibition of discrimination by failing to prevent the segregation of Roma children in schools. The court emphasized that the education provided in these special classes was not adequate to address the specific needs of Roma children who are disproportionately represented in such settings. I would like to mention that this case is might be relevant for Slovenia as well. Namely, placement of Roma children in special schools has never really been seriously addressed from the perspective of the principle of non-discrimination. Further, last year, in 2024, the Strasbourg court also decided in a landmark case on racial profiling. In Wabeil versus Switzerland, the court ruled that Switzerland violated the prohibition of discrimination, Article 14, in conjunction with the right to respect for private life, Article 8 of the Convention, due to racial profiling during an identity check. This is happening all the time in all of our countries. The case involved Mr. Wabeil, a Swiss citizen of Kenyan origin, who was stopped by police in Zurich train station. The ECHR found that the identity check was discriminatory and that Switzerland failed to provide an adequate remedy for the violation. Last year, the Strasbourg court also reiterated the principles it has established already in Opus versus Turkey in 2009 in the field of domestic violence and its relevance to gender discrimination. In a new case, Vieru versus Moldova in 2024, it again confirmed that the failure of the authorities to properly investigate a death of a victim of domestic violence violates the prohibition of discrimination. I need to mention one more important case from 2024, the case of FM and others versus Russia, which involves allegations of human trafficking and labor exploitation of women from Kazakhstan and Uzbekistan by the Russian shop owners. The ECHR found Russia in violation of Article 4, prohibition of slavery and forced labor, and Article 14, prohibition of discrimination of the European Convention, due to inadequate legal frameworks, insufficient protection for victims, and the failure to conduct effective investigations. The court also highlighted the intersectional discrimination faced by the women due to their gender and immigration status. I think this is quite a progressive decision. Recent case law of the EU Court of Justice in Luxembourg on non-discrimination has also focused on many areas relevant to our work, like reasonable accommodation for disabled workers, the prohibition of discrimination based on body weight, the scope of EU law in relation to self-employed workers, as well as the recognition of status of transgender people. In March 2025, the Court of Justice in Luxembourg delivered its judgment in the case Delditz. The dispute concerned the refusal of the Hungarian authorities to update the gender marker of a transgender refugee based on the finding that the applicant had not undergone gender reassignment surgery. So this was a condition that the Hungarian authorities wanted to impose in order to change the gender marker. Interestingly, the case was not built on any fundamental rights or equality claim, but only on the compliance with the principle of accuracy established in Article 5 of the GDPR, the General Data Protection Regulation. The Luxembourg court ruled out this practice, thus affirming that surgical treatment is not a relevant condition to benefit from a right stemming from EU law. The decision was considered momentous for several reasons. In a moment when trans rights are under systemic attack globally, the Court of Justice is expanding the protection of those rights under the EU law. This happens not only via the traditional non-discrimination law, but also through other legal instruments, such as the GDPR. More importantly, this case marks a turning point for the Court of Justice departure from its medicalized understanding of transgender identity. Another case from the Court of Justice that I want to mention concerned age discrimination. This is the so-called notary's age limit case. In October 2024, the court held that setting an upper age limit of 60 years for first appointment as a notary does not violate EU non-discrimination rules, provided it pursues legitimate labor market objectives and is both appropriate and necessary. This is a very relevant case as many of our jurisdictions contain age limits for various professions, including legal professions. For example, in Slovenia, it's 70 years for the judges and minimum 30 to start the function of a regular judge. Now I would like to move to the Slovenian Constitutional Court and say a few words about its recent case law that was relevant for the non-discrimination field. The Slovenian Constitutional Court is considered as relatively progressive, probably due to its recent decisions from the last couple of years, in the field of the rights of LGBT community and in the field of reproductive rights. In 2022, before I joined the court, the Slovenian Supreme Court issued a decision granting marriage rights and joint adoption rights to same-sex couples. The court's decision added to the already comprehensive legal framework which recognized equal rights of same-sex and opposite-sex partners, apart from marriage and joint adoption. With two decisions issued on the same day, the Slovenian Constitutional Court became the first court to grant these two remaining rights on the same day. In several other countries, the highest courts found the prohibition of marriage for same-sex couples unconstitutional. For example, in South Africa, Germany, Taiwan, Argentina, Ecuador, Brazil, and Malta, to name a few of them. Usually, when the legislature passed the legislation to implement this decision on marriage, they extended the effects of the court's decision to joint adoption rights as well. But the Slovenian case is specific, as the decisions of the Constitutional Court explicitly referred both to marriage and joint adoption. This decision was issued before I joined the court as a judge, but it actually, I have to say, it made me quite proud to join the court that was able to adopt such a progressive decision in the field of the prohibition of discrimination based on sexual orientation. The decision was the conclusion of a struggle for equal rights of the gay and lesbian community, which lasted for at least 40 years. The second decision that I would like to mention in the context of equality law is the decision on access to assisted reproductive technologies, ART, as I will call them from now on. This is another issue that the Slovenian society, lawyers, and politicians have been dealing with for many decades. The issue actually goes back to 1977, when access to ART was recognized to heterosexual couples and single women already in 1977. Much later, in 2000, a new conservative law on ART was adopted, limiting access to ART to heterosexual couples with fertility issues only. In 2001, the law was amended to expand the right to all women, but the amendment was quashed by a popular referendum called by conservative groups. Since then, it was politically impossible to touch upon the issue, especially since in the meantime, there were two referendums on gay marriage in 2012 and 2015 that the conservative groups won. Finally, the issue was resolved by the Constitutional Court based on two requests for the review of constitutionality. One was filed by the minority in the parliament, while the other was filed by the equality body, the advocate of the principle of equality. The Constitutional Court found in favor of the complainants. It found the rules on access to ART that include only women in heterosexual partnership discriminatory against single women and women in a lesbian partnership. This judgment is important for another reason. Namely, for the first time, the Constitutional Court had the opportunity to define the content of Article 55 of the Slovenian Constitution. This article defines a freedom to make decisions on the birth of one's own children, family planning, basically. This is the main and only provision in the Slovenian Constitution on reproductive rights. This provision had a very important history. Namely, this provision was a reason due to which it was not clear whether the Slovenian Constitution, after the independence, will be adopted in 1991. The new Slovenian parliament at 1991, after the independence, was relatively conservative, and many deputies demanded that this so-called abortion provision was eliminated from the Constitution. The deputies finally came to a compromise in the wording of the provision, which no longer explicitly mentioned abortion, but guaranteed the right to decide about the birth of one's own children. The Constitution was adopted with a large majority. What is even more important is that in addition to the articles of the Constitution, there was also an official explanatory text that was adopted for each particular provision of the Constitution. In this explanatory text, it is explicitly mentioned that this right encompasses the right to contraception, the right to abortion, and the right to ART. In its decision of 2024, the Constitutional Court had the opportunity, as I said, for the first time, to explain the content of Article 55, relying on the explanatory memorandum from 1991. With this, it further reaffirmed that contraception, abortion, and ART are protected rights in Slovenia on the constitutional level. For full disclosure, I was recused from the case, and I did not vote because I prepared the application. So I had to recuse myself. I was in the group. There was a group of people who prepared the application. And thank you to the colleagues who prepared it with me. I would like to point out that the inclusion of this provision of Article 55 into the Constitution should not be taken for granted. There was a great struggle behind it, organized by women, including scholars, professors, politicians, and activists. I am noticing, though, that after 35 years of this struggle, the struggle is sliding out of collective memory, and these three rights, seem to be taken for granted. So I think it's really important to educate younger generations about this, as it is not guaranteed that the rights, once they are acquired, will be there to stay. The struggle might need to be repeated. The constant calls for banning abortion that we are seeing in different countries is a strong reminder of that. In that sense, I would really like to compliment the initiatives that are taking place concerning this issue. For example, in Slovenia, it is currently possible to see a theater show called Article 55, produced by the Slovenian Youth Theater, Slovensko mladinsko gledališče, that takes the audience back in time and discusses women's realities before abortion was legal, but it also takes us into the center of the political struggle for the inclusion of the Article 55 into the Slovenian Constitution. Another initiative that I would like to congratulate is the initiative My Voice, My Choice, that is calling upon the European institutions and member states to ensure safe and accessible abortion in Europe. An example showing us that in these dark times positive change is possible are France and Norway in this particular field. France also included the right to abortion into its constitution, and Norway just recently extended the legal limit for abortion from 12 to 18 weeks of pregnancy. I would like to mention another decision of the Slovenian Constitutional Court that is also related to the prohibition of discrimination, but it concerns a different discrimination ground, the ground of age. The case concerned the question whether the employer could terminate an employment contract without needing to justify the business reason for that, when the employee met the conditions for old age pension. So we are talking about, here, this is the point where we're talking about age. The Constitutional Court emphasized that under international law, the ILO Convention 158 and the European Social Charter, a justified reason must exist for the termination of the employment contract initiated by the employer. Therefore, the Constitutional Court concluded that such a termination of the employment contract deprives the employee of an appropriate legal protection. The Constitutional Court annulled the disputed legal regulation primarily for this reason, but the case is also relevant for age discrimination, as the measure affected only older workers who met the conditions for the old age pension. So with this, I'm slowly wrapping up my presentation of the cases of the Constitutional Court in Slovenia that are directly or indirectly related to non-discrimination or equality. In the last part of my presentation, I would like to focus on what I think is one of the most important aspects of human rights law, including the prohibition of discrimination. This is the issue of the non-retrogression of rights, also referred to as non-regression of rights, or simply non-backsliding. The principle of non-regression is a human rights principle that prohibits states from taking steps that would reduce or eliminate previously established human rights or protections. It is closely linked to the concept of the progressive realization of the economic, social, and cultural rights, and it emphasizes that while states should strive to improve human rights protections over time, they cannot diminish those rights once they have been established. This concretely means that one of the legal principles that should be mainstreamed is the principle that once the right is recognized on the international, regional, or constitutional level, the standard should not decrease. This includes the practice of courts that are competent to interpret the provision of each body of law. Hence, if the European Court of Human Rights recognizes a certain right, it should adhere to its own established practice when deciding on new cases. Similarly, if the National Constitutional Court recognizes a certain right under the provisions of the Constitution, it should also adhere to its own established practice when deciding on new cases. I do not see that problem of departure from the court's case law in cases when a court first did not recognize a right, but later, for example, due to new legal arguments or due to changes in the composition of the court, decided differently and recognized a certain right. Lowering of the already achieved legal standards in fundamental rights would undermine, so why is that important? It would undermine the fundamental principles of our legal systems, including the rule of law and the protection of fundamental rights. Maintaining the high standards ensures predictability, fairness, and legal certainty for individuals and businesses. This is especially true for the European Union and the European Union law. In this sense, a good solution has been found in the EU law, as many new EU directives include a clause on the prohibition of the lowering of the already existing legal standards in the individual member states when these member states are transposing directives into their national legislation. This principle of non-regression has been applied in various contexts, including environmental protection, climate change commitments, and the protection of economic, social, and cultural rights. I believe it should be extended to human rights law in general, including the non-discrimination law. The legal developments in this field were so fundamental and have impacted people's lives in a positive way, in such a transformative manner, in how they can live their lives in a dignified way, that it would be a civilizational disaster to reverse them. I believe that in the current times, where dangers to human rights and equality are actually lurking from all possible corners of the political spectrum, this principle is among the most important ones. With this, I would like to thank you for your attention and conclude this address. Thank you very much.